So a black man, I just knew things have changed. So, Mr. Speaker, I want to bring to the attention of the House a matter that is very important. Mr. Speaker, as you are aware, the issue of our main business here is legislation. And one of the biggest predicaments that we have faced on issues of legislation, Mr. Speaker, is the issue of public participation. Public participation. So, Mr. Speaker, I want the House to take note of the ruling of the Supreme Court that happened the other day, Mr. Speaker, on the finance bill that was suspended by the courts, Mr. Speaker. And the bench at the Supreme Court did a very thorough work, Mr. Speaker. And I want to congratulate them because they have laid basis and foundation now for a proper public participation, Mr. Speaker. Mr. Speaker, I want to urge members to read that judgment, Mr. Speaker, because that judgment has really helped this country. It has cleared the path for this country now and for Parliament to do proper legislation, Mr. Speaker. Mr. Speaker, for the last 10 years or so, since the new constitution was enacted, Mr. Speaker, Parliament could not do this business, Mr. Speaker. Any legislation we do here, any act that's assented to by the President, Mr. Speaker, somebody goes to High Court and the High Court declares that act unconstitutional, Mr. Speaker, when in the actual sense, an act could have 73 or even 80 clauses, Mr. Speaker. And instead of a judge declaring the 10 or 15 clauses that someone has a problem with, many times judges have declared acts of Parliament unconstitutional, Mr. Speaker. If you read the judgment of the Supreme Court now, Mr. Speaker, and I read that judgment last night, it gave me a lot of hope. And I said I must bring to the attention of members that now the country is going to the right direction in terms of legislation. The Supreme Court said, one of the best things the Supreme Court said is that Parliament doesn't have to convince the public on what they are doing or the legislation. They just need to inform them. Information, Mr. Speaker. You don't have to convince because we are here to legislate on behalf of Kenyans. We are exercising sovereign power that is delegated to us, Mr. Speaker. So the Supreme Court, in their own wisdom, said that you just need to inform the public. You don't need they don't have to agree with you. Because legislation is not being done in the public, it's being done in the floor of the House. One of the things that has shocked me about public participation, one time, one of the judges declared one of the acts unconstitutional. And he said that the advert that was released to the public was done in English and not Swahili. And himself is doing his judgment in English. He did not do it in Swahili, Mr. Speaker. So, Mr. Speaker, without belaboring the matter, time is ripe now for the public participation bill to come to this floor of the House. The Supreme Court has spoken on it. The Supreme Court has cleared the path. Now we need to get a proper public participation bill on the floor of the House so that we can dispense off with that matter once and for all. Kenyans have suffered. Kenyans have suffered in the sense that any legislation that is made by the representatives is normally declared null and void and unconstitutional by the courts, Mr. Speaker. The courts are legislating through, I don't know how to describe it, through the back door, Mr. Speaker. So, Mr. Speaker, that matter must come to arrest. But I want the majority leader to weigh on this matter. And I also have the issue of femicide, Mr. Speaker. Femicide. Our women are being killed, Mr. Speaker, Kenyeji. Even today, there is one that has been killed and her body parts thrown at Eastligh, Mr. Speaker. At Eastligh. Another one, at Langata. But her origin is from Eastligh. So, Mr. Speaker, that matter also we need to talk about it, but let the majority leader pronounce himself on the issue of the Supreme Court and public participation. Thank you.
Thank you, Honorable Speaker. Let me first commend the Leader of Minority, the Honorable Junet Mohamed, for raising this issue on the matter of the judgment, and also take this opportunity to commend the Supreme Court. Because, Honorable Speaker, the architecture of a constitution, and we must thank God that under the 2010 Constitution, the Supreme Court came into being. Because, Honorable Speaker, as an advisory court also, they have now set the pace, as the Honorable Junet Mohamed says, for us to be able to enact substantive legislation to guide our public participation exercises in the legislative processes of this House and even those of the other House and our county assemblies, Honorable Speaker. Honorable Speaker, I want to agree with the Leader of Minority that in line with Article 2 of our Constitution, that says that the people may exercise their sovereign power either directly or through their democratically elected representatives. And those democratically elected representatives are the men and women who sit in this House and in the Senate, Honorable Speaker. And more so in this House, because it is this House that represents the people. And that is why you will find also in this Constitution, many of the bills that become law can emanate from this House and become law without going to the other House, to the Senate, Honorable Speaker, because we represent the people while our Senate colleagues represent our counties. And that is why those bills that touch on counties and county governments must, as a matter of the Constitution, go to the other House. And may also emanate from that House, but must be completed in this House. And that is why I've always argued, Honorable Speaker, since 2013, when we began this new system with the bicameral parliament, that we don't need to belabor which House is superior to the other. If one House can enact legislation and it becomes law by itself, and the other House cannot enact legislation and it becomes law by itself, it has to go to the other House, then it goes without saying which House is the upper House, Honorable Speaker. But that is not the point, Honorable Speaker. The point is that public participation has been abused by a number of our judges, especially in the High Court. And I must commend the Supreme Court and those other judges who have exercised judicial restraint in making determination as to what constitutes good public participation. And I've read previous judgments on qualitative and quantitative analysis of what is good public participation, Honorable Speaker. But the Supreme Court now has put it very well. And I want to agree with Honorable Junet that it was misconstrued that public participation is a referendum. And in fact, during the public participation exercise of the impeachment process of the former deputy president, there are those who argued that way. And there are those who believe that we are going to carry out a referendum exercise. Public participation is to go out and collate the views of the public. But it's still up to the members of parliament to consider the views of the members of the public. And they may not necessarily be the right views. And you know, Honorable Speaker, it is said that opinions are as many as, I don't want to say what they say out there, but you know what they say, that opinions are as varied as you know what. And everybody has theirs. Therefore, as many views as we will get from the public, Honorable Speaker, the onus is still on us as the lawmakers to consider all those views, balance those views.